Welcome back to the Morning Brief, and we're diving deep already into the first leg of our conversation, which is the rule of law and assessment of the judiciary under the last administration in the last 1 year. A difficult conversation to have, I must tell you, particularly because it's a sector that is constantly under scrutiny and whose actions are also dependent and consequent upon other arms of government. But it's also important to have it all the same, you know, because it's the jury is out there on whether or not the judiciary is indeed the last hope of the common person. So has the administration ensured that indeed the judiciary caters to the justice needs of all Nigerians on that social ladder and in a manner that is not only independent, but also seen to be free and fair? Joining us to have this conversation, we have two gentlemen: Senior Advocate of Nigeria, Mr. Ahmed Raji, who joins us from our Abuja studio. Good morning and welcome, sir. And we'll also have joining us here in our Lagos studio, Mr. Jiti Ogunye, legal practitioner. Good morning, gentlemen, and welcome to the program. So I'm going to start from what the administration promised. That's what we've been doing characteristically. And I understand, gentlemen, that this is a difficult conversation to have yet again, particularly because you are distinguished men of the bar who also have to stand before your lordship in court. And so we appreciate the Herculean task that you're helping us with, gentlemen. So let's look straight at the promises: judicial independence and integrity. And what is promised under this is we will institute far-reaching reforms, assuring the financial independence, impartiality, effectiveness, and most of all, the integrity of the judicial arm of government. Now, there are different layers to arriving at this destination. You can take it one by one. I'm going to start with you, Mr. Ogunye. We can take it one by one. Either it's appointment of justices to the Supreme Court, to the Court of Appeal, also looking at other aspects. Maybe you want to start with judicial appointments. Have you seen reforms to that extent?
Well, I've seen a departure from...
Okay, pardon me, Mr. Green. We'll have to address your audio. So I'm going to go to Mr. Raji to start off with this. We want to address your audio very quickly. So, Mr. Raji, I'd like you to start off on that one. Have you seen reforms in that regard, if you've been following the conversation?
Reform in terms of what?
The first layer of promise in the administration's manifesto, which would be judicial independence and integrity, instituting reforms, assuring financial independence and impartiality of the judiciary. And I said that there are many layers to that. You could talk about appointments. You could also talk about even remuneration, but whichever one you want to take first.
Well, I thank you very much. The administration is just barely a year old, and I think they're just implementing their first budget. And but that notwithstanding, I think in the areas of appointment, they've allowed the judiciary to call the shot. And what do I mean by this? This is the first time since 1999 or thereabout that the Supreme Court is having a full complement of 21 justices. I stand to be corrected. It has never happened. And this was an exercise strictly between FGSC and NGC. Yes, the President must have to approve, the names must have to be submitted to the Senate, but the procedure, the processes, mainly between FGSC and the NGC. And we cannot be talking of impartiality without looking at the mode of appointment and how much of interference the executive is allowed to wield. I think by far, or by and large, what I've seen and what I've read,
Mr. Raji, can you still hear us? It appears we have audio challenges through to Mr. Raji, but he was beginning to set the tone indeed for this conversation. And I'd like to believe that you were also listening to him, Mr. Ogunye. Perhaps you have some reactions to some of the things that he has already started off by saying.
No, he was just taking off. But I was saying that I've seen some departure because you posed the question whether we've seen reforms in the last 1 year, and I'll say that I've seen some departure from what used to be the case as far as the handling of judicial business, particularly as it relates to the issue of appointment of judicial officers is concerned, and that's quite significant. And this is not an attempt to indict the past administration that was very disturbingly lethargic in handling judicial appointment matters, but that's just putting it the way it is. Whereas in the past, it was very difficult to move the executive to do the necessary appointment after the clearance by the NJC and after the clearance by the Senate, particularly as related to the Supreme Court of Nigeria. This administration has done that with dispatch, and that's very significant. So much so that for the first time since 1999, the Supreme Court of Nigeria is just having the full complement of the court under Section 230, subsection 1B of the Constitution, which provides that the Supreme Court may have up to 21 judicial officers. And so because people may be wondering, what's it with the numbers? Are they not too many? And so on and so forth. The number is significant because if you're talking about constitutional cases, for example, 21 will only provide a panel of 3 of 7 justices. And so if you're talking about ordinary appeals, you have 5 justices, meaning that at most you can only have 4 panels. And so in the immediate past, there was a time when the Supreme Court was struggling with 11, 12. It came down to about 10 sometimes, and people were wondering what was going on, And so that's quite significant. As to whether that's indicative of reform, that's not just reform, that's, just following the law, implementing the law. So reforms are deeper. They are more fundamental. They are not just embroidery, administrative embroidery relating to appointment, etc., etc. So we've seen that departure, and given the recent event in Abuja about administration of justice and reforms and all that, we hope that something tangible, something substantial will come from there. So we've seen swiftness in confirming appointment. We've seen a full complement of the court, Supreme Court of Nigeria, since 1999, and that's quite significant, given the volume of cases that their lordships have to handle at the Supreme Court, and given how full the docket of the Supreme Court is currently. So much so that cases, sometimes ordinary appeals, not criminal appeals now, or political cases or constitutional matters, may last there for 3-4 years. So it is very significant that we had that, and hopefully we'll have other reforms. I may go ahead to speak about other things, but I'd rather, subject to what you may think, that since the silk in Abuja was disappointed by technology, you will resume, and then so that as it was just taking off, it could get to cruise scene level.
All right, Leonard Silk, we would like you to take off from where Mr. Ogunye has left off. Mr. Ogunye talked about how, appointments have been done swiftly, but then again, there are in his own words, administrative embroidery, but that does not, affect the real matters of judicial reforms. Perhaps you have, reactions to that. And maybe you want to talk about remuneration as well.
Well, let me start with remuneration. We're all aware that since 2007, the salary structure has remained the same. 2007. And it's so unfortunate that a director in a parastatal earns more than the entire Supreme Court justice salaries in a month. From CJN down, there are some directors in some parastatals who earn more than what the Supreme Court justices all combined together earn in a month. Now, this regime has put in place a very holistic review, which is very commendable. We have to commend both the Mr. President and the Attorney General for looking into this, and we understand work is almost completed, and the salaries and remuneration generally will be something that will be in tandem with the realities of our time. Otherwise, you talk of judicial independence and the pay is not good. Of what use is independence without economic independence, so to speak? So for this regime, we have to commend them for this. And I understand it's up to about a 300% increase, which is highly, to me, very commendable, because the take-home pay of an average judge is nothing to write home about, and it speaks volumes. But this regime has come to reverse that, as far as my knowledge of the ongoing is concerned. So that is my take on remuneration. And the appointment, which my friend has mentioned, just like he rightly pointed out, this is the first time we're having a full complement of 21 justices of the court. This is going to have a great impact on their work, and this will begin to see us from the next academic session, or judicial session, whereby the court can have at least 3 panels sitting at a time. This is going to decongest the court, because we have a lot of cases before them, and because they were few, they are hampered. There was not much they could do. And now with 21 justices, 3 panels, making either 5 justices or 7, as the case may be, can comfortably sit. So we're going to see the effect of this in months or years to come, whereby the docket of the court will become lighter and what to do. So, and recently, there was a justice reform seminar organized by the Attorney General, and a whole lot of holistic review took place there, which, if properly implemented, will further assist. So, and I think judicial independence and all those areas you have mentioned.
All right, let's see. If we can bring the conversation back to the studio, Mr. Ogunye, let's come back to you on some issue, because we're going to be pandering around judicial administration and administration of justice, the places we can have those conversations. And one of the pillars that this government has promised is going to be one of their 4 or 5 pillars in the judiciary is access to justice. But I want us to speak to some issues. It may not be on case basis, which has to do with discipline in the judicial system or in the judiciary. We've seen all kinds of ludicrous things happen, respectfully so, where we have had ex parte orders, interim injunctions from courts of concurrent jurisdiction. In fact, there was a case, I remember our correspondent was telling me of where we had, I think it had to do with one of the states in the South, where the same case, upstairs, downstairs, giving different orders, but they were a court of concurrent jurisdiction. How much of discipline, you applauded the fact that there's swiftness in the embroidery process, as in your words, to make sure that these courts are filled with the right judges and all of that, the numbers are good. But in terms of discipline, to stop some of the things we see that gives the judiciary flax, which are some of these orders and interim injunction, how much of discipline are you seeing in that area?
Well, the judiciary is structured in such a way that the disciplinary body is part and parcel of the judiciary itself. Perhaps because it is felt that it will undermine the independence of the judiciary if an external body were to be the body to sanction. So the judiciary, a way therefore, is a self-regulating institution. And so in Nigeria we had the NJC. There have been criticism, not only now, but in the past, about how the NJC, and in particular the chairman of the NJC, are positioned in such a way as to be the body that does almost everything in the judiciary. From appointment, yes, you have the Federal Judicial Service Commission. In the state, you have the State Judicial Service Commission. But no appointment is made unless the imprimatur of the NJC is put there. And so from appointment to discipline to administration to sitting as regular justices of the Supreme Court, it is felt that the NJC is too big and that it has to be restructured. Many suggestions have been made. But relating to discipline in particular, we all know that there is a code of judicial conduct which regulates the conduct of judicial officers, apart from other laws that are in the polity. And so judicial officers are expected not to do certain things, and there are also, from time to time, directives and directions that are issued by the NJC. Now, I have a fundamental problem with the alteration or modification of the law regarding discipline of judges recently via judicial pronouncement, via case law. And this not related strictly to discipline, but they're interwoven and interconnected. Before now, it was possible to get a judge that a law enforcement agency believed had committed a crime to be arraigned. So no judge had judicial immunity against prosecution. But the Gajua case came up, and it takes away to the Supreme Court. And the Supreme Court held in that case unanimously that it's only when a judicial officer is removed from the bench, that's the summation, that judicial officer could be proceeded against. So if no petition is raised against a judge, because wrongs can be corrected without being detected, wrongs can be committed without being reported. Okay, so if no report is made, but it's obvious to an anti-corruption agency that a judicial officer is corrupt, because when you're talking about bribery, which is an aspect of indiscipline, for example, it takes two to tango. Right. If the giver will not squeal, the taker may not tell. And so between the two of them, the other people are put in darkness, including perhaps the victim of that corrupt practice, who may not have any tangible evidence to prove anything. So if it occurs to anti-corruption agency by some intelligence gathering and all that, they can't do anything. And so what do? They would then be expected to go and petition the NJC. A body that receives petition is not going to petition the NJC. So I have a problem with that. But regarding the issue of discipline, the NJC has been doing its best to discipline judicial officers. A number, we know, disciplined. But it's a tough situation, I must confess. In many of the cases that require disciplinary sanction, these are political cases. We don't have this very much in ordinary cases, save some infractions. But in political cases, you are talking about one of the South states, River State. We have a burden one now, not burden, a burden, an emerging one. In Kano State, where you just see that over the same subject matter, two courts of coordinate concurrent jurisdiction are just dishing out orders. And then the appellate courts will now be the clearing house. That is not acceptable. And so my expectation is that going forward, the NJC will have to do more to sanction. You recall that the last time this came to the fore, very disturbingly, the NJC came out strong, even against lawyers.
And I remember
who
that
are
time.
Forum shopping and procuring, clashing and conflicting expert orders. So the NJC can be said in that regard to have intervened, but I've said that it's a tough call because beyond rules and regulations, beyond the code of conduct, there is the human element.
Okay, Mr. Ogunye,
these judicial officers, perhaps, who are to be sanctioned before they came to that bench, are also recommended by the higher judicial officers who are supposed to try them, and so on and so forth.
Let me
the human
bring in,
element is there.
So before Kayode comes in, I don't know what the procedure in court is. My layman's assumption is that if you come, for instance, the popular cases where they do sometimes forum shopping and all of this, if you come before me as a judge and you are seeking an ex parte, I will feel that the judge should ask whether there's already a subsisting ex parte. Isn't that the procedure, so that I will know whether or not?
The judges can randomly ask, but they are not compelled to ask because they may assume that there are no such whatever. But in the procedure, in the Federal High Court, for example, in the procedure, you filing an action, there will be an affidavit that you say that this matter is not being litigated anywhere else. There are no cases like that and all that. So all these steps are being taken because there are steps, innovative steps, to contain this problem and menace every day.
Okay, let me bring in the senior advocate, because this is at the heart of this conversation, really. This taste of the pudding, they say, is in the eating. So if Nigerians are trying to rate this government, this administration in the past 1 year, they will look at what they can see, the things they hear, and Mr. Ogunye has talked about two of them. So the Rivers case, there's been a lot of back and forth. And as a result of that, we've seen how the political situation has sort of worsened over the past few weeks. And a lot of people look at the judiciary and say, well, we come to you, make this pronouncement, and let us move on from this. But it looks like we're now building a lot of other things on it, and it looks messy right now. The Kano situation, of course, we have that on our hands right now. Even the case with former governor of Kogi State, and there's been a lot of back and forth. And at this point, there's been silence on that case so far. So is it that the judiciary doesn't want to make it look as though, some of our people have made mistakes, and then that might smear the image, the integrity of the judiciary, so they keep this on the wraps? Because it's important to make examples of these people so Nigerians know that, okay, the judiciary is strong when it comes to discipline. Senior advocate, that's for you.
Buddy?
I said that's for you.
What is the question, please?
Well, the question is about discipline in the judiciary. I referenced the case of Rivers, where we've seen coordinate courts making orders that are sort of opposing. We've seen what is playing out in Kano State as well. I talked about the case of a former governor of Kogi State, where we've seen courts giving conflicting orders. And the courts are the ones meant to resolve the cases, not cause more issues or confusion. So my question is regarding discipline. Why has it been hard to see that discipline coming through for Nigerians to see as example that the judiciary is disciplined?
Well, I think the NJC has always disciplined judges who abuse the power to grant ex parte order in a frivolous manner. We have had instances where judges have been cautioned or suspended, and in some cases dismissed. But that is not to say that ex parte order is alien to our law. It is provided for in the rules. And as to the issue that you raise, conflicting ex parte orders, under our rules, when you are filing an action, under most rules now, you are supposed to depose to affidavit of non-multiplicity of suits. That is, this case that you have filed, no similar suit has been filed by you. Where a counsel knowingly does that, I think it is not the fault of the judge. That should be, it is the counsel that should be dealt with. You mentioned Kano. I do not think we have any issue of conflicting orders in Kano. As far as I know. Are you with me?
Yes, please. Yes. Go ahead, Senior Advocate.
Yeah, I'm not aware of any conflicting orders in Kano. There is a fundamental human rights case before the Federal High Court, and we have a chieftaincy matter before the State High Court. Where is the conflict here, as far as I'm concerned? And before you talk of before you deprecate a judge for giving conflicting ex parte orders, he must have notice of the earlier order. It's not just to say that, oh, somebody has given it, like what happened some few years back, another was taken in Kano, somebody went to Imo to go and take another order. How will the Imo judge know that another was given in Kano, except it was drawn to his attention? How will he know? So I do not think, while I'm not saying all judges are dangerous, I do not think it is right to accuse them of just indiscriminately issuing out conflicting ex parte orders. Ex parte order is not alien to our law. It is part of our law. It is to cater for emergencies.
So, Senior Advocate, if I could come in here quickly, the premise of this conversation, if I could come in quickly, the premise of this conversation is going to the courts to resolve issues and having those issues resolved clearly for people to see, not going to the courts and then it's resolved for one person, the other person goes to another court, it's resolved in favor of the other person, and both of them come with the court orders or judgments and say, well, it favors me. And you are now left to pick and choose which of the orders, and then these things drag on. So the point is, rather than have the judiciary solve these cases, what we're seeing is that it looks like the judiciary is creating more confusion with those orders that the people are holding on to. I say, this supports my position. The other person says, well, this order supports my position as well. And they keep clashing. And I've given examples across those states or those issues.
I think in the example you have cited, it is the lawyer that should be dealt with, not the judge, and the party to be fined. If you have gone to one court you have what is unfavorable. Instead of you to pursue it there, you now go to another court to go and file another suit without disclosing to the. I had a similar situation where a judge made an order innocently. Unknown to him, the party had gone to another court before, and when it was brought to his attention, he vacated the order. So, but let us not be talking of the effect. Let us go to the root cause. It is the lawyers who engage in that should be disciplined, and the party to be fined. So, why is the fault of the judge who does not know that something like that has happened? So, why do you blame him? I think the lawyer should be disciplined. But where a judge, after his attention has been drawn to an existing suit or an existing order, formally, improperly, and refuses to act on it, then the judge may have some explanations to make. I won't say disciplined. He may have some explanations to make.
Well, it would be difficult to fault you on your disposition to these issues. But as much as possible, would like to cover as much ground as possible. If we look at what the administration presents that it will achieve, let's go to another level, which is respect for the rule of law. And the promise here is a Tinubu government will operate on the premise that the rule of law is paramount. Let's just leave it at those two lines. I'll come to you now, Mr. Ogunye. If you look at the handling of the former chair of the EFCC's case, Abdulrasheed Bauer, who was released after 100 days in custody, you can look at the handling of the case of former CBN Governor Godwin Emefiele, just to mention a few. What are your thoughts? How do you weigh in on this administration's disposition towards respect for the rule of law based on its promise?
Using those two, what has happened to those two persons as a case study, one can say that the rule of law is alive in Nigeria. One of the essential pillars of the rule of law is equality of all before the law. I mean, as a person, I would have been surprised if Godwin Emefiele is not facing courts on multiple charges in this country today, including some that have not even been thought about. People died as a result of what he did in this country. But you know, we are people that, you know, pains are inflicted on us, and because of so many problems that we face as a people, we tend to forget the number of, you know, the entry points of the pains. So it was good that the mighty, the powerful, the rich, the politically strong are brought to justice, just like the ordinary people. It may well be that some may argue that, look, if another administration had come in, if another person had won an election, Emefiele could still be a free man. You know, that is an act of vendetta. But Emefiele is not pleading vendetta in court as a defense. And so, for me, it's an indication that the rule of law is kicking and alive. Regarding Bauer, his treatment, he spent 100 days. The individual has not come out to challenge his detention. He's not come out to challenge his detention. There are some people who are taken to custody and they stay in custody and start negotiating. So you are outside, you are wondering why they should remain silent, why they are not fighting for their liberty. And they say, no, it's okay by them. They just want to quietly negotiate and get out of trouble, given what they've done. Now, I will expect that if allegations were made against even that person, allegation based on corrupt practices, being the head of an anti-corruption agency, there is no person more suitable to face the wrath of the law than that individual. so that an example can be made. That matter is as important as the matter involving the CBN governor, if you ask me. Because you are the one who asked that question. Because here was the head of an anti-corruption agency who was accused of engaging in corrupt practices. There were no investigations that were conducted. There were no prosecution. Yet there was a removal. And he went home quietly. You know, people celebrated that he had been released. And that's the end of the matter.
You can add the Minister for Humanitarian Affairs case to it as well. Better edu.
Better edu. Yeah, it's better that investigations concluded and prosecution is made. Not only better edu, the other person.
Sadiq.
As many as you have.
The investigation is still on, Nabi.
We've been told that investigation is still on. We'll assume that investigation will be conducted quickly because I'm not a law enforcement expert. I don't work in the FCC, and therefore I may not be able to time their investigation. But I had assumed that if the person who had taken had come out to say I've taken money, and we are told that recovery has been made. So what legs of the investigation are remaining for prosecution to be delayed? So those are the aspects that may point out to the average Nigerian, that the principle of equality of all before the law that I've talked about as an essential pillar of the rule of law is not being observed across.
Mr. Ogunye, I want to take this to, let us say, Mr. Raji, and it's a simple question. Is the judiciary indeed the hope of the common man? The reason I ask, if you look at the ICPC or the EFCC, the lead anti-graft agencies, and you look at their number of convictions, a lot of Yahoo boys, but the people that people suspect pilfered, squandered our commonwealth. There are people that were really not much, they were not successful in anything so much, they became government officials, they became super rich. We can't trace their sources of wealth, whether they are governors or members of the National Assembly, whether at the federal or the state level. And then when it comes to their cases, we see these things happen that it takes such a long time, and how many convictions have actually been attained by the anti-graft agency when it comes to top public officials. It's just like it's a battle of attrition or judicial attrition. Just keep going, and it wins out and everybody goes home. But there's a closure when it comes to smaller cases and smaller fries. So is the judiciary indeed the hope of the common man? Leonard Silk.
Well, thank you very much. Well, I think judiciary is trying its best. As far as I'm concerned, is the hope of common man, and it's not as you have stated it. In this country, Darie was jailed, former governor of Plateau State. Have you forgotten? The sentence was...
My apologies, Leonard Sek. I'm saying we can literally count on our fingers top officials that were jailed.
Let me land. Okay. Let me land.
All right.
You see, the trial is not as easy, especially for somebody who has been in charge of government affairs, to wade through the evidence, to assemble it and present it to the court. It's not easy at all. And this is where we have to commend some of these prosecutors. I don't want to mention names, who have been putting in their best to make sure some of these matters are properly presented for them to secure some justice for the society as a whole. So, and announced, and prior to commissions, they do a lot humongous amount of money.
Well, it seems we're having a little issue with the connection, particularly with the audio, senior advocate. So we'll resolve that. The connection's a bit tricky, especially via virtual framework. But let's come to a studio. You know, we can touch and feel Mr. Ogunye, and he was making a point about... yes, please, but we'll come back to you, Senior Advocate, but I want to quickly bounce this off Mr. Ogunye. He was making a point about prosecuting government officials. It's hard, it's tough compared to, I think, prosecuting the average Nigerian. Well, he's speaking perhaps from experience, but then should that be the case? Shouldn't be, I mean, same way you approach the prosecution, the same vigor, the same energy and all of that for the average Nigerian, the same should be for government officials as well. So we don't have to count on our fingers the amount of people prosecuted at least and convicted on the government side.
In civil litigation, you are asked not to sue a man of straw because you may not be able to recover damages if he doesn't have money. Conversely, in criminal prosecution, it's difficult to successfully prosecute a person with deep pockets. That's the reality. And it's not just because people don't want to secure justice or prosecutors. But the reality of our situation is that that politician, is better able to, hire the best lawyers in town who are familiar with the courts, who are experienced, who are known to the judges, and who can get one or little concessions, even in proceedings, okay, to his advantage, even without compromising the tenets of the law. And then he is also in a position to compromise and suborn witnesses, to pay them off, to disappear. He's in a position to do so many things. And prosecutors, particularly the ones that whose names have not been mentioned in the FCC, we are doing a lot of things just to succeed with prosecution of one or two of these persons. So it's tough. Again, there are certain aspects in prosecution that the prosecutor themselves are not in control of. I mean, if you look at the use of Kalu's case, and I'm not afraid of making examples. How will you rate the disposition of a prosecutor and his stamina to continue prosecution when after the thing sneaked through the entire gamut of the judiciary at the apex court, the whole thing was squashed, perhaps because the Arbitration of Criminal Justice Act was a new act which was being tested. And what's the technical ground? A justice came from the Court of Appeal to try, as provided by the law, that everybody thought was innovative and good. And then the matter got to the Supreme Court and said, how can a law provide that a justice that had been sworn at the Court of Appeal should come back and, preside and conclude the prosecution so that the matter will not start de novo? Nobody anticipated that. And that was it. So to come back and say you are, who is going? So there are a lot of problems, and so we must say that. However, that doesn't mean that government prosecuting agencies shouldn't strive more than they ordinarily would have done with ordinary citizens to ensure that the mighty and powerful, including those who are government officials, who are found wanting, who are found to have engaged in corrupt practices, are successfully prosecuted. That's how to vindicate the rule of law, particularly regarding the issue of equality of all before the law. It is said that be you so high, the law is higher than you are. And that's how the ordinary people will get the feeling that the law is indeed ruling. And that's important because in society, the ordinary cases of those who have stolen yams, who have stolen cocks and all that, they are not seen, they are not heard by the society. But it is those who are alleged to have stolen mind-boggling money, from the public till, that the people look at and ask themselves, do we have a future in this society? Is democracy working? Is the rule of law working? Is justice, criminal justice administration, is it working? And so on and so forth. So once examples are made of those, I think that this will impact even public officers regarding their conduct when they want to pilfer public money, and they will be restrained thereby by what has happened to,
and it is indeed because of the scarcity of that example, that rhetorical question, is judiciary indeed the last hope of the common man, seems to be eternal. It seems as if we have inadequate time perpetually to address these issues. But there's something that we always do, gentlemen, for the assessment of each sector under this administration. We give a percentage mark. We could do results and effort. So I'm going to start with you now, Senior Advocate via Zoom from Abuja. What percentage would you award this administration in terms of effort and result in the judiciary sector so far, based on what we have discussed, and indeed, areas that we didn't cover? Would it be average or below average or above average?
Definitely more than average. I will score them 80%.
80%? Even
though there is room for... Yes, I will score them 80%.
Wow,
even though there is room for improvement.
Okay, that's a part.
I'll score them 80%.
In fact, that's a distinction. All right, Mr. Ogunye.
Yes.
Efforts of this administration in the area of judicial reforms and all other gamuts that we've not covered, and then results and effort. What would you score the administration? Unification
of the retirement age of judges, attending to the remuneration of judicial officers by increasing their salary, appointing the full complement of the Supreme Court judges for the first time since 1999. That should go for 70%.
So that's a distinction.
That should go for 70%.
Wow.
There is room for improvement, particularly relating to other areas. And this may, the 70% may become 30% going forward. Because one of the things that we've been talking about in judiciary is the structure. The judiciary has a structure of a pyramid. Tiny summit, 21 justices, then in the Court of Appeal, over 120, perhaps 100 justices, and then in the High Court, many judges. Feeding the Supreme Court from the appellate stream and then the original jurisdiction stream. 21 persons cannot handle these jobs alone. So you need to restructure the judiciary and have regional, at the very least, regional appellate system, regional Supreme Court to take ordinary cases, so that the Supreme Court can be free to take constitutional matters. Indeed,
a subject for the men of the bench to reflect on, and the administration indeed. But I'd like to thank you very much, gentlemen.
My pleasure.
Mr. Ahmed Raji, Senior Advocate of Nigeria, who joined us from Abuja via Zoom. Thank you very much. And Mr. Jiti, legal practitioner, who joined us here in Lagos. Thank you very much indeed for your time.
Yeah.
And after this time out, we'll be looking yet again at another matter that also bothers on the law, but also on administration, particularly at the grassroots level. It's an important conversation that you don't want to miss. So join us again after this time out.